If someone dies without a will, who inherits their house when they don't have biological children and never legally adopted their stepchildren? When there is no valid will, the house passes under intestate succession laws, not based on what the family thinks the person wanted. Stepchildren generally do not inherit through intestacy unless they were legally adopted. There are rare, fact-specific cases where a court might recognize an equitable adoption theory, but you should not assume that applies. The first question is whether there is a surviving spouse. If there is a surviving spouse and there are no children or other lineal descendants, the spouse may inherit all of the real estate in some situations, or only a partial share if a parent of the person who died is still living. Then the remaining share goes to the next relatives under the statute. If there is no surviving spouse, the house typically goes down the blood relative line in order, first to parents, then to siblings and the descendants of deceased siblings, and then to more distant relatives like grandparents, aunts, uncles, and their descendants. If there is a signed or notarized document that was never properly made into a valid will or recorded as a deed, it may not change who inherits, and it can create title issues that slow probate. The practical next step is to open an intestate estate with the Clerk of Superior Court so an administrator can be appointed, the legal heirs can be identified, and the house can be transferred or handled correctly.